Constitution Basics. An outline of the Constitution. Australians need to understand what the purpose of the Constitution is, what the key features of government are, including separation of powers and division of powers, and why a referendum is necessary to change the Constitution. The Constitution is a legal document setting out the basic laws for the Government of Australia. After a series of conventions in the 1890s, the Constitution was created by representatives of the 6 colonies. Before it came into effect on the 1st of January 1901, its terms were approved, with one small exception, by the people in each colony. Western Australia is not in the original preamble proclaimed on the 9th of July 1900, as they were originally reluctant to join the Federation, and did not hold a referendum on the question of federation until the 31st of July 1900. Although our Constitution was given legal effect by an Act of British Parliament, in reality, the Constitution is a document that was conceived by Australians, drafted by Australians, and approved by Australians. The British Parliament no longer has any power over Australia, and the Constitution's power, as a fundamental law of Australia, relies on the Australian people's decision to approve and be bound by the terms of the Constitution. The preamble is a concise summary of the rationale and principles behind the Constitution and is often symbolic of the history and aspirations of a new nation. The Australian Constitution highlights the colonial origins of the Act, that is, where people of the separate and self-governing colonies, now called the states, agreed to join together to unite and become a new nation, the Commonwealth of Australia. The Constitution was created on the assumption that the rule of law would operate throughout Australia, with equality before the law deeply ingrained in it. The Constitution requires that the government obey the law and provides checks and balances to ensure that occurs. The Constitution is deliberately structured into chapters to create a legal and political system that governs Australia. Rather than one central body holding all power, the Constitution has 8 chapters to spread power between the federal government and states, called the division of powers, and between the legislature, executive and judiciary, called the separation of powers. The division of powers ensures that all power is not held by one level of government. Sections 51 and 52 limit the areas that the federal government can make laws about, called exclusive powers. These are predominantly national issues such as defense and immigration. The states can then make laws on all those areas not covered in the Constitution. We refer to these as residual powers. These include state issues such as health and education. As state governments are generally closer to the community, they are able to deliver services that meet the needs of their community. If there is any conflict between state and federal laws, the federal law will override the state law. The Constitution is also structured to provide for separation of powers between the legislative power, those who make the laws, including our members of Parliament who are representatives elected by the people of Australia, executive power, those who put the law into effect, which includes those who administer the business of the government, and judicial power, those who interpret the law and conclusively determine legal disputes, which includes the courts. Each of these powers must operate in accordance with the Constitution. By separating and putting limits on power, it ensures each body works within their area of responsibility, as defined within the Constitution. This provides checks and balances to avoid power being held by one single body, and is instead distributed across the 3 bodies, which ultimately ensures that it is the people who rule. The High Court is established in Chapter 3, as a final court of appeal, and to interpret the Constitution. The High Court is a powerful check that ensures the legislature and executive act within their roles as defined by the Constitution. In particular, Section 75 requires officers of the Commonwealth to act within the law. This is a key element to the rule of law, where all people, including those in power, must follow the law. The High Court also ensures any laws made by the legislature are consistent with the Constitution. These disputes may be between governments, or between citizens and governments, over the limits of the powers defined in the Constitution. The Constitution provides for the 2 pillars of an independent judiciary, tenure and conditions of service. By outlining the remuneration and length of service of the judiciary, it ensures the judiciary is not easily influenced by those in government and safeguards the impartial independence of the courts. The Constitution is the people's document, so it can only be changed by the people. It would not be good for the stability of our nation and system of government if those in power, such as the government of the day, could easily change the Constitution to further their own political or personal interests. As a result, the Constitution has outlined a specific process that is required to get the consent of the people before the Constitution can be changed, known as a referendum. The required elements needed to change the Constitution are: first, the proposed change must be passed by the majority of both houses of federal parliament. Then, the majority of Australians must vote in favour. Finally, the majority of 6 states must have a majority of voters in favour. Changing the Constitution is deliberately a difficult process to protect our foundational document and ensure that it is the people of Australia who decide whether they are in favour of making any changes. The Constitution has only been changed 8 times since its introduction in 1901. The last change occurred in 1977. The Australian Constitution is a mechanical document that outlines the allocation of power and responsibilities between the federal and state governments and sets up the 3 branches of government. Because the creators of the Constitution believed our rights were best protected by a parliamentary democracy, it does not contain a Bill of Rights, and only contains a few express rights, such as the right to trial by jury for offences against Commonwealth laws. Some implied rights are also identified. At the end of the day, the Constitution is a document for all Australians that sets out the basic laws of governance in Australia. As Sir Philip Fish, former Premier of Tasmania, said in 1897, "We have cleared the way to federate as one people, and we are a united people, so soon shall we forget that we live not for ourselves only, but for others, and for the great country to which we belong." Our Constitution has a past and a future. It does not merely exist in the present. It is the basic law of Australia,